Welcome, everyone. As Ian noted, I'm Lori Ann Czepiel, and I'm a partner with Nelson Mullins. I help entrepreneurs and companies raise money, create an infrastructure and a corporate governance system so that they are investable, and also exit through M&A or IPOs. Nelson Mullins is a 125-year-old law firm with offices across 31 cities in the US. We're here in Boston, New York, and Miami, and we have leading practices that are dedicated to blockchain, data security, and fintech. I'd also like to welcome Anastasia. Thank you, Anastasia Stull. She is the executive director of AssureReg and an of counsel with Nelson Mullins. Anastasia had been with the SEC Division of Enforcement as an attorney. She has been a general counsel of a division of Merrill Lynch in London, and she's an expert in regulatory compliance and solutions. Philippe is to my left. Philippe is an attorney from France. He is an international blockchain expert and received one of the first PhDs in the world in blockchain law. Philippe also is an author on the subject and teaches at the Sorbonne International Law School. He advises clients on legal, data, and cross-jurisdictional issues involved with ICOs. Welcome.
Thank you.
And Matt MacDonald, in the other blue jacket, is a senior manager at Wolf & Company, a 110-year-old CPA firm and risk management firm. He's focused primarily on the financial services and banking industries. Matt spends much of his time supporting prudent security and risk management practices for his clients. Most recently, he developed a blockchain and distributed ledger technology, a strategic practice at Wolf, where he and other tax and audit managers support the many complicated, transformative regulatory and compliance changes in the market. Welcome, everyone.
Thank you. Thank you.
Thanks. So legal issues involved with blockchain are broad, complex, ambiguous, evolving, and frankly could have consumed the entire 3-day seminar. So for the next half hour or so, our expert panelists will highlight some recent developments with an eye toward giving you a sense of how to analyze, strategize, and navigate these issues to create the foundation for an investable and successful blockchain project and ultimately business. So Tasia, based on your many years as an enforcement attorney, what trends do you see coming out of the SEC or other agencies that might tell a good story about what not to do or illustrate any guide rails for our entrepreneurs to follow?
Yeah, thank you. And just want to say first, thank you so much for being here. This is so much cooler and more exciting than the banking and legal conferences that I go to. Anyway, I spent the majority of my career in Washington, D.C., working with the alphabet agencies, mostly in the financial regulatory area. So that's the SEC, the CFTC, Federal Reserve Board, OCC, Treasury, FinCEN, FDIC, OCC, did I say that? Did I leave anybody out? And of course, also working with a lot of state regulators. And we're seeing significant engagement. However, there has been little formal rulemaking, but it's coming. The administration is really flexing its muscles, and with the executive order that came out earlier this year, from President Biden, there were a lot of initiatives that they laid out and this whole of government approach to how we're going to manage blockchain and digital assets, a huge push toward making sure that America is a leader in CBDCs and ensuring that there's safety and less criminal activity, that investors can feel good, and that consumers are protected if they want to get involved, and that there's more market confidence. I think certainly the more regulation we see, the less kind of like this will come out of the darkness and into the light. And there's still so much education that needs to go on. But as far as trends go, as I said, there's been little formal rulemaking. I think there are 28 states that now have addressed litigation in some respect with respect to either blockchain or smart contracts or other verified credentials. There have been taken two approaches at the state level, and some of them have like just purely exempted crypto or other digital assets or other forms of blockchain from the rules to say, okay, they're not money transmitters, they don't need a license. And then some of those states are like Wyoming and Colorado. And then there's also an approach where they're prohibiting states from accepting cryptocurrency. And there have been warnings, and of course, New York has more of one of the more stricter jurisdictions for state law, and unfortunately for them, it's caused a lot of organizations to try to avoid New York. Yeah. I think they've realized that was probably not a good thing, and so there seems to be a little bit of softening around the edges of regulation. They're maybe trying to attract some of that business back to the state. Hawaii and Maryland took similar approaches. But I think it was one of the crypto panels earlier in the conference here where they were talking about how we need to meet the regulators where we are. They are definitely coming to us. There's a lot more innovation, a lot of more, cyber units, and sometimes it's for enforcement purposes, but it's also for innovation. Chairman Gensler at the SEC has stood up its own innovation unit and hub and has asked for people to, entities and innovators to come and speak with them on a no-name basis to try to get the advice that they need so that they can make sure that they're not running afoul of the regulations. But I mean, there are so many areas to regulate. There's cryptocurrencies, sales practices, money transmission, taxation, mining, and the ownership licensing. So of course it's confusing when you have all of these different agencies, some of them like looking for their own stake in the process. I think when it comes down to digital assets, we may see the SEC and the CFTC kind of splitting the baby there. The Department of Justice has been very aggressive. They have taken their position as the law enforcement and regulating this industry very seriously with respect to detecting wrongdoing, investment, and prosecuting criminal activity. There were 3 different reports that Department of Justice came out with, and they were not urged by the White House to do this. This was purely by their own initiative and engaging the FBI to try to address, to make sure that there weren't funds that were actually going to like weapons or drugs, to try to make sure that there was no money laundering, and then of course that any investors that were participating in the industry were not being defrauded. And they had a more significant focus in this recent release, which just came out last week, on DeFi and NFTs, which they hadn't focused on before. I know there's been some international activity with the UK, and maybe Philippe can tell us a little bit about that, but they are also trying to create more of a safe haven in the UK, trying to ensure that there isn't any illicit trade finance there, and really giving more power to law enforcement to like freeze those assets in the event that they find that there is some wrongdoing. So,
Philippe, why don't you jump in and talk to us about the international issues?
Yeah, what's interesting about that is that what happened in the world is happening on the blockchain. We thought that blockchain would change the world. It actually just reflects the world. Like, for example, you got the American blockchain. The American blockchain is naturally dominant, #1. They don't come up with new laws because they don't need to. They don't come up with, Bitcoin is not even a cryptocurrency for America. I mean, the American law is pretty clear about it. It's a commodity. Mm-hmm. Why? Because Americans already have the best currency in the world, US dollar. And crypto, Bitcoin is far, far away from the US dollar. So there is no threat to that. Now, about the rest of the world, You got the Chinese that are usually, as usual, like what they did with the internet. They're trying to take the blockchain technology and control it in their own way. So they've been trying to work on the digital yuan for several years, still not coming out, but it's okay, we're used to that. The Libra never came out, Diem never came out, so we are still watching because basically everybody's watching each other. And again, it's the reflection of the world. The Americans are watching the Chinese are watching the Americans, the Europeans are trying to act to look like they are doing something about it, but of course we're not doing anything because we are watching the Americans. That's all we can do. We come up with some laws, that's very interesting. We're doing this the European way, which means that we have 24 countries talking with each other. One of them left, you mentioned it, UK. They left and they came up with some new ways of trying to tax international financial network because they have one of the best financial network, which was one of the problems they had with Europe. And this European law that is just being passed right now, when I say right now, understand for the last 5 years, this law that is still not out has been strongly lobbied by which country? The French. Usually it's the French and the Germans who try to lobby the European laws. On that one, the French were the fastest because we use some tricky way. We're French. We use some existing law. We slid some law about the crypto in it, and then we came out with this law. Nobody follows it. I'm a lawyer. I can tell you, we don't know how to apply it in France, mostly because we don't have any crypto market. Why? Because, again, America. I mean, seriously, are you guys going to invest on a French crypto company? I don't think so. I wouldn't. Now, because of that, we still have the right to go and knock on Brussels' door and say, we're the first one with a European law. That's why the European law is influenced by French. But don't worry. Again, European law is not going to do anything because we're still watching for the American law. And as you know, there is still no American crypto law because you're applying the existing financial laws, some of them dating back to 1933 or 1934. Why? Because you can. Because you can, because you have the best and strongest financial market. We don't. We have an atomized market. 15% is France, 50% is Germany, and the rest is atomized between several European countries. So we have no weight. We are divided, atomized, but that's one way of protecting ourselves. It's another story. Now, getting back to China, stop me if I'm I mean, I did a thesis on that, so I could literally talk about it for 2 weeks. But my point is, going back to China, again, they're trying to do with blockchain what they did with internet, which means that try to use the technology, control it through a couple of gateways. And what they want to do with blockchain is have a blockchain that is controlled by the government, which by definition is the complete opposite of blockchain. But then again, they can. So we're going to have we're having this dynamic between America and China and a little bit of partnership with Russia over there. But Russia is yet different because their internet is even separated from the world internet. Now, the interesting part, and that's what I'm saying, it's reflecting the world history, is that 6 months ago, when I completed my thesis and I defended it, one of my conclusions was that the Russians have set up 3 crypto centers with which they're working on crypto, and they have specific laws that they are geographically isolated. It was Belarus, Crimea, and Donetsk in the Donbass area. As you can tell, it was surrounded Ukraine. So my understanding is that whatever is happening in Ukraine, they already knew they would, of course, they knew they would be doing that, but they're using these crypto centers as a way to try and go around the international sanctions. So again, the crypto is a reflection of the current history. And if you want to know what's going to happen with crypto, roughly, I would say just open a history book. That's my understanding.
Well, and I think we also can look back to the evolution internationally of the standards adopted in Dodd-Frank and Sarbanes-Oxley as far as a roadmap for how international regulation and laws might develop here. There, the US government adopted these standards. US institutions, commercial banks, investment banks, and so forth, started requiring them even for companies that were not subject to the jurisdiction of the relevant US laws. the securities and other regulatory authorities in the US worked internationally with their counterparts to extend our standards under these laws to those countries and modify them somewhat for unique national and country-specific market issues. So my guess is that that's how this will work, because it's a lot of the same regulators who are involved in these issues, and they are either elbowing out new developments in the regulatory space, or the touchstone for how all of the folks here, your advisors, accountants, and lawyers think about these issues. They're historic touchstones, but that's the way our laws develop here. So I think that it might not just be because of specific, unique characteristics of folks in different countries, but there might be a model that we'll follow.
Yeah,
and privacy is another good example of this. Matt, maybe you can talk a little bit about privacy concerns and security issues and how those have evolved nationally as well.
Yeah, absolutely. And great to be here. It's really always great to be in an event like this. Like you mentioned, I do spend a lot of time in banking and finance, so it's kind of nice to have a little bit of a bright discussion. But I think first, before the privacy concerns, I think I want to touch upon what both Anastasia and Philippe said was the executive order I found to be a whole lot of nothing. It was a hurry up and wait mentality that I think that we're now going to just wait again to look for what's the frameworks that's going to come out, what's going to be the sort of sanctions or the responsibilities of different agencies. So reading that, I think it was kind of strange, but also to your point about CBDCs and the reasons that we have blockchain and those sort of distributed ledgers is not to create transparency. It's transparency with privacy. And with CBDCs, I'm going to start to get a sense that they just want everything to be out in the open. They want to see all the transactions. They want to see who's managing those transactions, where it's going to and from. And that's all well and good for government, but that's not going to work for the original use cases of it, is to have private, immutable, and hopefully authentic transactions between parties. So I'm interested to kind of see as we get closer to CBDCs being established, number one, is it only going to be for corporate and government agencies, municipalities that want to trade with each other, but also what are they going to peg it to? Because we've seen time and time again that, as you're mentioning with fiat currencies, is that it's a moving target constantly, and to peg a digital currency to something that has no intrinsic value, I think is going to be a very difficult one for them to sort out. Mm-hmm. So those are kind of my initial thoughts on both what my panelists said, but I also kind of wanted to speak a little bit to the privacy concerns as well. And I don't necessarily know if there's privacy concerns, but at a personal level, I'm concerned about knowing your customer, the authentication approaches that we're utilizing currently, and what that's going to look like in the future. Because right now, I'm sure many of you, when you want to sign on to Coinbase or onto any other exchange, they're taking a photo of you and that's it, and maybe you punch in some information. That's pretty easy. I'm a cyber guy. That's pretty easy to get around. And then with New York and things like that, where they're being super restrictive, there's really easy ways to get around the AML provisions and the knowing your customer provisions, like in New York or otherwise. So the privacy, I think, is, for me, not as much of a concern as the authentication of that individual while you're seeing the transactions and the different money movements that are going to occur, especially internationally. The sort of sanctions that we're trying to push on China or Russia, North Korea, and things like that. It's really easy outside of the bounds of US sanctions to move money and to move a lot of money and to manipulate markets, frankly, without that. So those are kind of the initial thoughts that I had with security concerns, I would say, and authentication concerns. Privacy, I think it's still kind of up in the open. I think that majority of transactions are private until someone steals the data off of a API or off of a ledger or something like that. But I think time will tell as we kind of get better with managing data warehouses and managing key management and the governance around that level of infrastructure.
Yeah, I'd just say one more thing about, you mentioned the executive order again, kind of at the bottom of it. The thing that I saw is that they were going to be increasing the penalties significantly for money transmission. Mm-hmm. And we do so much of that work, helping, with the due diligence and ensuring that our clients have the proper licenses that they need. And a lot of times they don't even know that they need them. We've had a few deals go through with partners that after the deal they found out that they needed licenses in 50 states. And that can be pretty devastating for people on both sides of the deal. But the fact that they are, I know that's not going to be good news to our clients. So that was kind of like one thing that I was like, ouch.
Very high cost.
Right.
Yeah.
Very, very high
Right.
cost. It's almost a barrier to entry that they're forcing,
Right.
which is concerning because I think to your point, or I think it was your point that they're creating an innovation hub. They're looking to establish, no name, come in, talk to us if you think there's a problem. But at the same time, I think they're stifling a lot of that innovation and a lot of the practices that we kind of so need to become the forefront as a U.S. Nation for the digital assets and what comes next.
Right, and in Gensler's recent speech, I think he said that out of the 10,000 tokens that he believes that the vast majority of them are securities.
Right.
And so he's taking a pretty hard line on that. I know there was an enforcement action that just came out a couple days ago by the CFTC that had fines in like the $180 million range, and then its successor, they immediately slapped them with a lawsuit immediately thereafter. But I think, what was his quote? He said, Gensler says, not liking the message isn't the same as not receiving it.
Yeah.
And so they're definitely making it known that yes, we want to play nice, but we're going to be pretty aggressive when it comes to enforcement.
And for the record, I do think all tokens are securities. You're trading a value for a second value, and there's transactions and taxes that have to come with that. But put everything on the table and allow the companies and the retail investors to actually understand what that implication is, because there's a lot of people out there making a lot of transactions and they don't know how to deal with the tax and the ramifications that come from it.
Philippe, the EU has been a leader in privacy issues. Maybe you can talk a little bit about how those issues may be different or evolving in this area, in the international arena.
We have this joke, Americans come up with new technologies, Chinese copy new technologies, and Europeans come up with laws for these new technologies. So that's basically what's happening. We come up with privacy laws, what we call GDPR. So it's very complicated. It's like a syndrome. There's lots of things to do, and we are not even sure how to apply it to the blockchain, because we have, as you mentioned earlier with me, we have this thing that we call the right to be forgotten. That's a strong opposition between Europe and America from this point of view. In Europe, we deem we have the right to be forgotten. In America, you don't think like that. Example, if somebody insults me, say about me that I stole money when I was 10 years old or something like that, my idea would be, of course, I sue the guy, libel, I can prove he's wrong, and then, okay. So the right to be forgotten would be me going to Google and say, remove everything about that, because I've proved that it's a lie, and I don't want this lie to be available. Otherwise, we think, if we want to tarnish the reputation of anybody, we would have to do, all we need to do would be say bad things about this person, libel this person, even if we pay a fine, and it would be tarnished forever. That's the European point of view. We have to remove that. The American point of view is no, it's part of history. Even though it's wrong, it's libel, you won the trial, so we put the libel and we put the trial, the correction, but it has to remain there. It's pretty much like these Nazi flags. In France, the Nazi flag is forbidden. It's forbidden because it's a symbol of oppression. It's a bad souvenir. We really don't want to have it anymore. America sees it as a victory, which makes sense. For Americans, it's a victory, not so much for us. So, of course, you're proud of it. That's one strong difference. Now, how do we apply it to the blockchain? How do we apply the right to be forgotten to the blockchain? And this takes us back to this problem that you mentioned between France and America. The right to be forgotten, in France, you can ask Google. Google is forced to delete everything that is asked to delete, but he keeps it on American servers. So a French senator came up with this very funny conclusion. We should tell Americans to delete everything regarding the French people when we ask them to. I mean, history has proved that when French people tell Americans what to do, it really works fine, right? So that's a problem. And the problem with blockchain is going to be the same. So my understanding is that the blockchain will be tampered with in Europe. We will have some overlaying protocol to correct or to hide some elements, and it will not be the case in America. So again, getting back to past example, but then again, the blockchain will not be exactly what we call the blockchain because it's not going to be transparent. So again, adaptability.
So Philippe, with this patchwork of issues and the competing demands and requirements in the US versus Europe, how does an entrepreneur or a company create certainty about which laws apply to them, whether through structure or through participants that they're working with? And in addition, are there jurisdictions to avoid? Like in the US, we have sanctions, and you should not be doing business with Cuba. I assume that may apply here as well. Or preferred jurisdictions. For example, when you're structuring something for tax purposes, you might run through the Caymans or the Netherlands.
Yeah, well, frankly, to tell you the truth, we don't do a lot of that in France because we have new laws. We have, as I said, we have a law in France that defines utility tokens. I mean, like Americans, like pretty much every country in the world, we don't need to define financial tokens. We just apply existing finance laws. But then what is a utility token? For Americans, for the SEC, for Gensler, there is no such thing as utility token, at least not so far. For French people, we came up with a law. You can define what is a utility token. Problem, and that answers your question, nobody's using that law. Why? Because if we were using that law, if a French entrepreneur decided to create a utility token, then American investors would never buy this utility token because they would be scared of what the SEC would do. Not today, because you mentioned, now we know what to do. Yeah, that's true, but the problem is that the SEC is actually studying cases that go back to 2017 and 2018. It's not me who said it, it's Gensler who said that a couple of weeks ago. So 2019, 2020, everything that's been done in America so far, it's still not under scrutiny by the SEC. So we still don't know what they're going to do. And French people are scared because, like everybody else in the world, we don't want to attract French investors. We want to attract American investors. So we're kind of blocked.
And that's where most of the investors in this space and venture investors are based. So
exactly.
You really don't have a choice, even if you wanted to get investors locally. That market doesn't really exist or hasn't been developed like it is in the US.
Pretty much. So the only way we could do that is that when we come up with a website, and again, not the blockchain anymore, this website where you can buy a token, for example, you have to answer several questions, KYC related, and the first question would be, where are you? And if you click United States of America, then the website shuts off. That's the only answer we have so far. But then again, this answer doesn't come from the blockchain. It comes from internet.
Interesting.
Yeah, and
Matt?
if I could add to that as well, especially to a lot of the founders or startup folks that are in here, focus on your threats and your risk assessment. So to your point about what are the concerns that we could potentially have in the next 90 days or 180 days or 5 years if you scale out, get an identification of what is the industry threats, what is the regulatory compliance threats, what are the threats to the marketplace outside of your competitors. Actually spend the time to build a matrix and to actually review it and evaluate it year after year. If you need any help with that, it's always someone that you can find a consultant or advisor for. But what we've found is that you're going to uncover a lot of things that you weren't aware of about where are you performing services or transactions in these 12 states that I didn't know I need the transmitter license for, or I didn't know that this particular government agency looked for this in this place versus this sort of transaction in this place. Those are the sorts of things that compliance people and regulatory people spend their entire careers talking about. But I think founders sometimes maybe don't always spend as much time on that. They're very product focused, very sales focused. But I'll tell you, the second thing, when you have that threat matrix and you have that risk assessment, you show that to a potential investor, showing that you got your game plan, your roadmap for what that's going to look like for you. That's really going to help you, answer the right questions or avoid questions that you maybe not necessarily know how to answer.
Right. I mean, we always say the 9 most dangerous words in compliance are, show me where it says I can't do that. So, going in and having that legal obligation inventory and understanding what those things are. I mean, we try to do it, but we try to teach our clients how to fish so that we, give them the framework so that they can repeat it next time. Maybe we help you with your first business, but then you have kind of the roadmap for, as you move along.
Yeah, you never want to jump into a pool where you don't know how to get out. So,
Right.
Well, and even if there isn't a law that's developed in an area you want to move into, you need to be aware of some of these enforcement and political undercurrents. I was representing a client that was looking to raise money, and several years ago, somebody in the San Francisco office of the SEC started fishing around with companies that were involved in the digital asset space that they work. And they made an inquiry to the company. The company hired a lot of lawyers. They had already been talking to lawyers about how to structure this in a compliant way. The inquiry went away, but the government and the SEC in particular does not send a letter saying, okay, you're absolved. Disregard those communications and those meetings we had. Fast forward several years later, the statute of limitations hasn't run. No one's heard from the enforcement folks at the SEC yet. However, as we're trying to help the client raise money, and one of the questions that any investor will ask or any strategic partner will ask is, talk to me about compliance with law issues and communications from regulators. And so of course this is disclosed, and it created a significant delay in the funding. It created a significant concern about whether the value was there in the business and what the future might hold for it, and whether the investor was coming into a situation where a big name would suddenly reattract the attention of the SEC. So as a startup founder, as a developer, you might think, oh, that's way down the road. It can come back to bite you, even if you haven't done something that's incorrect or illegal. Matt, do you want to pivot for a moment and talk to us a little bit about tax and accounting issues in this space?
Yeah, I think from a tax and accounting perspective, we think about AML, money transmitter licenses, the sort of provisions that you need at the onset of your accounting books and the way that you're actually creating your accounting ledgers. So especially these days, I think it's really important to recognize, maybe for the founders that are only utilizing blockchain or distributed ledger technologies for business functions, we're eventually going to start to see, finance companies and accounting departments utilizing the distributed ledger technology to actually perform accounting transactions and services. That's going to create a financial material principle, for all of you GAAP people out there, that's going to make your blockchain distributed ledger technologies a financially relevant technology, which is something that we haven't seen in the past traditionally. So when you go look and see what are the potential controls that could materially affect if our books are complete, accurate, with integrity, valid, everyone's looking at paper-based documents. Now we're going to be looking at smart contracts. We're going to be looking at the code development. We're going to be looking at the integrations for APIs that all could potentially affect how your accounting systems are supporting the real tax and the real bottom lines. I think ultimately what's going to happen there is people are going to approach that. The fraudsters are going to approach that. The hackers are going to approach that and try to manipulate the smart code and the vulnerabilities that are within smart contracts, either to change financial markets, to create headaches for companies that they potentially don't like or that they have as competitors. It's going to be a nation-state-based situation. So I think those are all kind of the tax and accounting problems from a cybersecurity perspective that I think that I can speak to. We're still a bit down the road for that, in terms of that applicability, but we are already seeing companies like ISACA, the Institution for Audit and Control, taking out blockchain security governance models so that they can apply them to publicly facing companies. They're based off of standard frameworks, pretty similar to what Executive Biden and his team have been talking about too. So I think when I talk about tax and accounting, I think it's also important to understand what is the cybersecurity implications of that. what we're also starting to see is in a lot of different states, they're creating safe harbor provisions. So if you can prove that you have a cybersecurity framework in place and you are a financially material company or have financial transactions that you're processing, and you can show that these 50 controls we've designed and operated effectively by an internal auditor or an independent auditor, if a hack happens and you have finances stolen or money stolen, you might be able to receive safe harbor from that because that's what the law says in Connecticut at this point. That's only going to be coming to the Commonwealth, going to be coming to other liberal states that really want to foster this sort of innovation and growth, but also recognize that there's advanced persistent threats that are constantly looking to manipulate and to change the markets that we're dealing with.
Yeah, we were also talking this morning, Matt, about I think Pennsylvania and Washington State are the first states to tax NFTs. So Pennsylvania's taken the approach that they're adding NFT to the taxability matrix. And then Washington published a scheme for determining the source relative to where it's actually taking place. So these are guidelines and they're not legislation. And kind of the crux of that is that they can be applied retrospectively. So Pennsylvania has taken the approach that they can go back to even like 2016 and tax NFTs. So
Yeah.
I don't know what your view is on that.
I think it's really strange because NFT is a function for technology, and art is taxed differently. Securities are taxed differently. Homes and real estate are taxed differently. So I think they need to kind of put their eye on the ball, I guess, and try to bifurcate between what functions of an NFT are establishing and how do you want to plan to tax that in the future, because NFTs have a bunch of different applications. Mm-hmm. I might have to look over my shoulder after this with the FBI and stuff after all these bottom stuff. But yeah, it's a great point.
Well, since this is a legal panel, let's talk a little bit about smart contracts. Lawyers and accountants deal with contracts all the time. Matt, maybe you can talk to us a bit about what you're seeing with smart contracts, and then Philippe and Anastasia, you as well.
Yeah, it's a real problem. So smart contracts, we have thought for half a decade or longer that was going to be what helped to support the legitimacy of all of the blockchain technology. And we come to find out that basically 30 to 40% of audited contracts can still be hacked. 75% or slightly less of flash loan attacks have had a smart contract audit that's performed in the last year. So from a smart contract perspective, are they safe? They're incredibly vulnerable. You have to remember that it's people that are writing these. There are people that understand them or maybe don't understand them. The functions that are within smart contracts are different and sometimes very complex, thousands of lines of code. And it still goes back to a people and a process which can be manipulated and hacked by others. So I think we're still kind of in the dawn of trying to figure out really truly what vulnerabilities can be potentially present, not only with the smart contracts themselves that create the functions and the legitimacy of blockchain technology, but going back to the risk assessment and driving what are the controls that govern the people, process, and technologies around that. It's really challenging, right? Phishing is still a problem. Social engineering is still a problem. Access and authentication to where development environments where smart contracts and the test environments sit, they're accessible by others that shouldn't be. So I think it's really a matter of, do you understand your threat? Do you understand the vulnerabilities that could be potentially present? Are you constantly looking to mitigate those threats, utilizing a defense in depth, which is ultimately a huge compliance and a huge regulatory risk that not only do founders need to address, but also their partners.
From a user and an advisor perspective, I do a fair amount of work with non-US companies. And we do the contracts, we negotiate the primary contracts because they're often governed by New York or UK law in English. And there had been at one point in time a desire to then replicate that contract in the local language. And that's kind of died away. Why is that? Because people spend a lot of time negotiating and drafting the primary agreement, and nobody wants to have a contract that's ambiguous or differs from that. And I think one issue that needs to be dealt with is how the coding of a smart contract translates back to what the legal expectations are, particularly when it's not just a binary question, you do this and that follows, but there might be discretion from the parties. They might have options within the contract. And I'm not sure that there are many lawyers. We have lawyers who are coders in our blockchain practice, but most lawyers are not very swift with some of the evolving technologies. So I think that's one hurdle. Companies are coming up. We represent a leading blockchain audit company that is auditing contracts to make sure, taking that leap and making sure that it is, in fact, reflecting, the smart contract is reflecting what the parties expect, that it works. If something develops, a change develops, or there's a force majeure, that it's properly playing out through the contract. So I think that's an area of a lot of great opportunity in this space as well.
The smart contracts are the crown jewels of most companies that are going to be planning to sit on the blockchain. So I think we're going to have to find a place where that is the predominant risk area that we're going to be focused on probably in the next 5 years.
Mm-hmm.
Yeah, I agree. It's a big problem for us because we have a huge shortage of developers, especially in France because we have the language barrier. And on top of that, we still have to go through the regular process. Like we have to register a company. Before even doing business, we have to register the company properly. It takes time. And by then, a competitor might already have stepped in from another country in the business that we were interested in. So that's everything you mentioned is actually a bigger problem even for us.
Mm-hmm. Tasia?
Yeah, I mean, I agree with my other panelists. How do you define an act of God? For instance, if something is supposed to be executed based on that definition, I mean, you can't necessarily list all of those things out. So I think there's still a lot of work to be done there.
I think we're just at about the right time to wrap. Do you want us to wrap it up? All right, so one quick lightning round question for the panelists. I didn't tell you about this, so you'll have to act quickly.
New York Yankees.
In a few words, what do you think we'll be talking about on next year's legal and compliance panel at this conference next year?
Self-regulation. I mean, I think that's, we can, and I mean, our firm and my colleagues and I and the folks I work with, we're taking the position that we can and must have self-regulation for this industry. And so hopefully we'll be, continuing to engage there.
I think there will be a problem between Coinbase and KU Coin or Binance, whatever the name is right now these days. I think we're going to see some huge problem between Coinbase and Binance. And there's going to be some fights, interactions, big events that we're going to be dealing with.
Mm-hmm. And Matt?
I think subcontractor arrangements, foreign-based parties that are working on US-based companies and entities that have code that are based in the US is going to create a lot of headaches, especially with the development teams that are in Poland or Ukraine or in other states that are outside of the US that have access to potentially really important and confidential information. So I'm curious to see how that's going to be affected as well.
Terrific. Well, thank you, everybody, for taking the time to listen to us this morning. And thank you, Ian, and your team for putting on a great conference. We really appreciate it.
Great.
Thank you.
Thank you.